Champlain room, microphone test, 1, 2, 3.
Well, good morning, everyone, and welcome again to the Court of Revision. We're going to get started with the consent agenda because we have two items today. We'll be holding the first item, which is the local improvement Leggett Drive, but I believe that one of my colleagues is going to be moving adjournment of the local improvement Ken Park sanitary sewers to June 24th, Court of Revision. Would that be? It would be Member Moffat. Is that the right terminology? Member? Yeah, or director? Yeah. Okay, good. So, moved by Member Moffat that the local improvement Ken Park sanitary sewers be adjourned to the June 24th Court of Revision. Carried? So all of you that signed up today, thank you for coming, but you'll be coming back on the 24th of June. And Mr. Marks wanted to comment on that?
10 seconds. Madam Chair, it's my understanding that Councillor Deans is arranging a meeting within the Ken Park community or at the Fred Barrett Arena, actually outside the Ken Park community, at the Fred Barrett Arena, and there will be notification to her community about that.
Good. Well, thank you for coming today, and I'm sorry that you had to come out. Okay, so we are going to go back to local improvement area for Leggett Drive. We have a couple of things to do first, and then also just a heads up, Mr. Mark, I want you to give a little talk about what was approved by Council yesterday. So, are there any declarations of interest? None. Confirmation of minutes for the December 13th, the January 9th meetings, and January 30th? Carry? Okay, so over to you, Mr. Mark. Yesterday, Council approved a policy regarding what we're talking about today. And actually, I think that it really was undertaken further to our very first meeting that we had of this court. And so I think that, therefore, it's a great opportunity for you to say what has happened from that.
Yes, Madam Chair, I believe it was you at the January 30th meeting who there were a series of questions about what the court's jurisdiction was. Issues had been raised about the length of time it's taken the city to bring these forward, and which are not within the court's jurisdiction. Staff undertook to bring this to committee and council for determination, and that has been done. The people associated with Leggett may not know about this because while notice was given to Kemp and Nichols Island with the item before council, because the Leggett notice had already gone out, it wasn't given to them. And I should note, because we only see Kemp and Leggett in front of here today, that a second local improvement has gone fully through the process. Swans Way was the first. It went through. There were no objections, and it was approved, and the bylaw has been passed. Nichols Island, which was the construction of a road on some land within Councillor Moffat's ward, has also gone through. There were no objections, and a bylaw will be before council at its meeting of April 24th. But to come back to the program that was before committee and council, council has adopted a three-pronged program in view of the fact of the time that it took for these matters to come forward. The three components are: there must have been a change in ownership since the construction of the local improvement. Secondly, a tax certificate must have been requested and issued by the city that did not show the local improvement charges as pending. And finally, the owners must swear or solemnly affirm an affidavit that says that they were unaware of the charges. And I would add, because I've had a number of questions in respect of that affidavit, when the charges get finalized, and the bills finally go out, we will include a draft form affidavit with that letter, so that one person's already paid their own lawyer to prepare one, but we will provide a draft form that people can utilize if they wish when we get to that final stage, which for Leggett, if the special assessment roll were approved today, we still have to give notice of that. They have 21 days to appeal. If they appeal, that's going to be even further off in the future. If there are no appeals, then the package would come subsequent to those 21 days. Thank you, Madam Chair.
And just a final comment on that. So if there is an argument about it's not the Court of Revision that makes the decisions on who gets a reduction based on the qualifications or qualifying for those three.
That is correct. That is not a matter for the Court of Revision, in my opinion, Madam Chair.
Okay, thank you. So anyone have any questions? No? We do have some speakers on Leggett Drive roadway urbanization. I just thought that we should look at where we are today, because we've gone at this now. Was this our fourth time? And it's somewhere, just to clarify what we're looking at. So far, on January the 9th, the Court of Revision approved a reduction of the local improvement charge from $427.79 to $304.80 per meter. And that was in accordance to the document 1. We also approved a reduction of 6.05 meters for property frontage for 250 Hertzberg and 300 Leggett Drive as a result of the road widening. What is up for discussion, confirmation today and comment is a decision further to the adjournment of the hearing to January 30th, which was then furthered to today, to hear submissions and to give consideration to frontage reductions of properties which may have unusable parts because specifically of the presence of the Kizzle Drain, and to finalize the local improvement special assessment roll. So those two things. So that's what we're looking for, submissions if you're speaking today. The other two pieces have already been approved by the court, and we'll be looking for comments, anything that you have to say on to do with Kizzle or the local improvement special assessment roll. Okay?
Madam Chair, I believe Mr. Martin may have, if you wish, an introduction on the frontage reductions of property which may have unusable parts because of the presence of the Kizzle Drain. I believe Mr. Martin has a presentation that he can put before the Court of Revision. Is that correct?
That's a good way to start. Good. Okay, thank you.
Okay, thank you, and good morning. We had a presentation here that spoke about Leggett overall. Is that any better? We had a presentation that spoke to Leggett Drive overall, but we'll focus on the Kizzle Drain issue. At the January 30th meeting, we had conveyed to the court that Kizzle Drain adjustments would be based for those properties that have frontage on Leggett Drive and directly abut the Kizzle Drain. That happens to, the drain itself happens to cross Leggett Drive in two locations, so this provision would affect, in fact, 8 properties. We also conveyed that it would be based on an approximation of the top of bank, which we derived either from as-built and or air photos that we have available to us, and that the adjustment will reflect a 15-meter setback from the approximation of the top of bank, which is generally consistent with the 2003 official plan. On that point, I just want to give a bit of background in terms of how we decided on the 15 meters from top of bank. We did converse with our planning folks. I'm not a subject matter expert on planning issues, but it's my understanding that when it comes to building restrictions at water courses, the official plan has 4 or 5 criteria. In the absence of a master drainage or sub-watershed plan, it's my understanding from the information that we got from our planning group that this particular area did in fact have a sub-watershed plan, and that there was a provision in there that a setback be provided from the center line of the drain. That is a bit different than what the OP speaks about. It typically refers to 15 meters from top of bank, so we erred in favor of the larger adjustment by measuring from the top of bank. This sketch is a bit busy, but it's just there to depict roughly how the numbers came about. This is at what I refer to the east end of Leggett Drive. It affects, it's down by the Hertzberg end of the project. Off to the left is the cross-section, if you will, of the drain. The center line of the drain, again referencing in a lot of cases the material available with respect to setback is to center line of drain. The red line is what would be the property limit in as far as the assessment information was concerned, which is what's used to derive the measurements. And our approximation of the top of bank is the green line, which again was in this particular case measured based on reviewing air photos. So the mathematics, gymnastics that we go through is simply referencing the green lines, which would have been the top of bank setback, to the property line. As a result of that, the adjustments for the 8 properties vary between just over 13 meters to over 32 meters in dimension. Again, that's a function of the relationship of the property limit used in the assessment roll versus where the top of bank setback would be. In sum total for the 8 properties, it's about 182.5 meters, approximately $56,000 reduction overall. That is the substantive difference or change since the January 30th meeting of the court.
Thank you. Any of our members have any questions? No? Okay. Well, thank you for your presentation. So we'll go to our delegations today, and the first one up is Mark Heyman. Please come forward. Just so we have an idea. Welcome.
Good morning, Madam Chair. Thank you for seeing us today. We'd also like to thank the court for putting forward, I'm not sure quite how it happened, but the proposal for landowners who bought the properties since that, since the 2001. We do appreciate that. That does make a big difference. I sent you a letter yesterday asking the court to make a decision on 2 issues I presented to the court. One is the corner properties, and I've presented written arguments to the court, and I would appreciate a decision from the court on this and a reason why. When I look at the evidence on the corner properties, I don't understand the logic that the court is using to arrive at a decision where some properties receive it and some don't. The second issue is that the work was already done in 1995, and the work that was done outside of our properties or our abutting properties was done solely for the purposes of putting in the mainline sewer and not a local improvement. So I showed you photographs last time comparing before and after. I submitted drawings, engineering drawings, to the city and the court that show there isn't a substantial difference. I'm not sure what else I need to present to the court to say the work wasn't done. So could I have an opinion from the court on the reasons why that would not be a valid argument?
Member Cadre.
Thank you very much, Madam Chair. Just coming back to this morning's agenda, and I think the Chair described it very well in terms of only dealing with the Kissel Pond issue, because the Court of Revision has made the decision on the previous issue that you did bring up. So why are we going back to that item?
I'm not aware that the court did make a decision. I have not heard a judgment on that.
Pardon?
As far as I can see, the court has ignored what I've submitted.
No, well, not from my opinion. I'm going to get a legal opinion from Ms. Bradley.
There were submissions made by many owners at the meeting of January 9th, including submissions made by Mr. Heyman on behalf of the companies he represents. And at the end of the meeting, the court did make a decision with respect to all of the matters that it heard that day. And those matters which did result in reductions were specifically referred to, but the intention had been that they had therefore not granted the reductions which had otherwise been, for which submissions had been made otherwise. But the minutes, I think, clearly reflect that decision had been made by the court on January 9th of all of the submissions that they heard that day.
That's right. And that is our opinion, unless Member Moffat says something differently. We, we have looked at this, we have listened, we have read all of your submissions and taken the all the advice under consideration. And yes, thank you for pointing out what also happened was the go forward for council to make the decision that they did yesterday. And that came out of the Court of Revision as well. But having heard all of your submission and others, the decision that we made were those decisions on that date. And as I said at the beginning of the meeting, we're here today to listen further to arguments regarding the work that's been done on consultation with the owners and between the owners and the city on the land specific to the Kizil Drain, and also to finalize that local improvement special assessment role.
Okay. If I am to appeal your decision, I would need to know why you made your decision.
Well, we made the decision because we listened to all the comments and we took it into consideration, and that was the decision that we made.
Yeah, I
and
understand.
We saw your submission. We heard your submission.
Yeah, I understand your judgment, and you've ruled against it. I'm simply asking for a reason for those decisions so that if I choose to appeal it, I have a reason of why you made a decision.
The original petition went along Leggett to Hertzberg. Went right to Hertzberg was the original petition. That was what was agreed upon by 15 of the 21 landowners back in 2001, and that's what was approved by council in 2001. Was the entire local improvement up to Hertzberg. We provided relief for partial for part of the corner on January 9th. There was 6 meters on each side, which was in response to what you had submitted. It wasn't everything that you wanted, but we came to a compromise, and that's what we were comfortable with doing.
Okay. Well, thank you for your time then.
Do you have any comments on anything else?
No, not right now, thank you.
Okay, well, thank you very much. Next, calling Patrick Ferris, Canada Research Park. Welcome.
Thank you, Madam Chair, councillors. I guess the first note I'd like to make this morning, I guess, is the limitation on the agenda only dealing with the Kizil Drain. Notwithstanding that we had a presentation in January 9th, January 30th was adjourned, so there's no opportunity to give presentations then or further submissions. We made a submission on January 9th dealing with the issues that affect Canada Research Park. We had no issue with the actual calculation of how it was done because we retained Novatech Engineering at our cost to correct the city's numbers at our cost. The city got it wrong. We spent that money to get those figures actually corrected. Dealing with the issue that we put out is dealing with the lateness of putting this special assessment levy out to the owners 12 years after the fact is, quite frankly, in my opinion, unconscionable. It's not good business practice. That's not the way we run our business. And I've submitted a letter yesterday to Councillor Harder and Mr. Tim Mark asking for why has the Court of Revision not addressed why this has taken so long to delay. The city has apologized and said yes, they recognize the delay. Where is the accountability as to why this is delayed? There was no less than 5 departments involved in 2001. Certainly somebody along the way should have realized that in good business sense and fairness to all the parties, get this thing done quickly so it's out there, so that businesses, especially commercial landlords, can have this flow through and be able to collect this from our tenants. The way it's currently structured, and I made this in my presentation on January the 9th, is this, and this is not addressed in the decision of the Court of Revision or in the 3 recommendations, is that it prevents us, and we are limited in our recovery against tenants as we normally would be. So this is coming directly out of our pocket at our cost. Had this been done in a timely fashion 10, 11 years ago, that wouldn't have been the case. In our business, if we do an error of this nature, somebody's accountable. We'd like to know who dropped the ball, because somebody certainly did. The other issues are raised in my letter that I provided to Councillor Howder and Mr. Mark, is that the recommendations that Mr. Mark has put in his letter don't cover all the concerns and all the issues, quite frankly, and that's why we think this morning's agenda is very limited. I've made the point in our letter to Council is that Canada Research Park over the past 10 years has provided $80 million in tax revenue to the City of Ottawa. Certainly there'd be some issue of fairness in dealing with us and dealing with our issues. We're not asking for special attention, we just want a level playing field. The biggest issue that we have is that we are now impaired in being able to pass on these special assessment levies to our tenants, because many of these tenants are no longer there. We also deal with the issue of the limitation on the 3 criteria that was approved at Council yesterday, that we really had no opportunity to have any input into that. We think the criteria should not just be limited to those 3 things dealing with the purchase of the property. As I indicated in my letter, is that Canada Research Park is a conglomeration of many corporations. At the time, some of the properties out there, Mytel Research Park, weren't part of Canada Research Park. They were a separate entity, and we wouldn't have had any notice that they had that special assessment or a special assessment coming. So why it's limited just to purchase is again a question that needs to be answered. But I think the main focus of our presentation today is, first off, there has not been the adequate and reasonable opportunity to consult on this matter to come to a proper resolution. It leaves business with the impression this is being rushed through in an untimely manner. If it's taken 12 years to bring it to the forefront, then why is this being rushed through in the sake of a few months? Those are my submissions.
Thank you. Thank you very much, Mr. Ferris. And so you know, I did share the letter with the other members yesterday when I received it. And as far as the Court of Revision goes, and the 3 of us sitting here in this position that we're in today, we are not councillors of the City of Ottawa. And that's whether you're on our side or your side, it's a different concept for sure. So as far as answering as to why it took so long, we're not in a position to answer that as Court of Revision. I would say also that that's the comments that you made on the interpretation of the decision yesterday, I think, is a discussion you should have with city staff. Because I'm not, I have to say I'm not a councillor here again. But if I was a councillor, I would be saying that, because you have addressed us in that fashion, I would be saying that the issue that you raised about who was the owner and when that you took the ownership and all that sort of thing, maybe that's something that staff can clear up for you. Okay, I would suggest you have that conversation. But as far as the role of the Court of Revision, it's not our responsibility or right to comment on that particular part. As far as the approvals that we made on January the 9th, we did have due notification. We did have people that came out on December the 13th. We have taken our time. We believe that we have, and we know that there has been much consultation, and consequently, because of that consultation, there has been a significant reduction in the assessment. And so today, we're here to deal with anybody who has issues with regards to the work that has been done on the Kizzel Drain, and also to approve the local improvement special assessment, which has changed from our first meeting. Does anyone else have anything to say? Member Moffat?
On the delay, while I understand that the city has apologized for it, and it is unfortunate, we have several of these local improvements that we will look at that have been lengthy delays, but it's not the role of the Court of Revision to. I don't want to make light of the situation at all, but the Court of Revision doesn't have a pizza policy on local improvement charges. It's unfortunate that it's taken this long to get to us, but it's not our role to reduce the levy just because it has taken that time, unfortunately.
I'd like to make a further comment dealing with the delay and how it impacts business, especially Canada Research Park and other large commercial landlords. Our tenant base is largely technology and knowledge-based industries. It is a very competitive global market in attracting and retaining tenants. And we are inundated almost on a daily basis from business parks in the United States and worldwide trying to poach our clientele, which is our tenants, because it's a very competitive business market. And it may not, $500,000 to Canada Research Park, it may not seem like a lot of money, but it is, because that makes a difference from perhaps 50 cents a square foot to a tenant on their additional rent. They are being offered by parks in upstate New York, in Tennessee, in Raleigh, North Carolina, in California, and in Arizona to basically have much more competitive rates than we're able to offer because of the municipal tax structure. And this is why it's very important. I want to stress the point, the number of jobs that have been created in Canada North over the past 20 years. There's over 10,000 high-tech, high-paying, tax-paying employees in Canada Research Park and Canada North. That's not a small number. And we face that pressure each and every day in our business, trying to retain and attract businesses to our park. Who knows what the tipping point is? And I'm sure other employers in Canada North can speak to the same thing. They're being offered on a regular basis, please move, we'll move you down to the United States, we'll look after the cost. At some point in time, perhaps people are going to look back and say, where did all the high tech go? Well, it's death by 1,000 cuts. Those are my submissions.
And I thank you for that. And what you've just added, as a councillor, but not as a member of or chair of the court, I think it's a very important discussion you should have. And I see Councillor Wilkinson here, and we have a very vibrant economic development department now that is very engaged in just what you're talking about. And Sad Bashir, you probably have met with Sad. I would suggest, Councillor Wilkinson, that you set up a meeting on this specific topic, which is the poaching, if you will, of businesses from, well, poaching of businesses and what the city's interest is in it. And I think that that's something that you can take to have that discussion and perhaps have a report come to the FEDCO. But as far as what we are capable of in our roles of members, that isn't part of our decision making.
I understand the limitations of your jurisdiction today. We wanted to put this on the record.
And that's important. And I guess because we are in our other life, or 2 hours from now back to being a councillor, it's very important to us. So I hope that we follow up, and I'll make sure that we will work with Councillor Wilkinson in any way we can.
Thank you.
Thank you very much. Terry McIver, Children's Place. Welcome back.
Although I think this is kind of a major workout today. Terry McIver, the Children's Place, and would like to thank you for the opportunity to speak again. I'm here more. I believe we're going to qualify, and for the recommendation, I would like to thank everyone involved in that recommendation. It was very creative and insightful of you to, on the April 2nd recommendation, to do this. What I want to address, though, is support. I'm a member of the Business Improvement Association for Canada North. I'm not here to speak on behalf of them. I am here to speak on my support of them. And we understood, I certainly understood, that the city is very supportive of these improvement initiatives being developed. And part of why I got involved was it was going back to the original days in Canada where businesses supported businesses, businesses talked to businesses, and businesses worked things out. And so I'm here today because as we piecemeal each of these points, there are fewer businesses that are going to be here to support the 2 or 3 larger ones, and Canada Research Park is certainly one of them, Mark is one of them. And so, you know, when we settle our own issue and we think we can walk away from it, that's not morally correct. I have a responsibility to the Canada North Business Park to support those businesses in these concerns. I also have another issue. As a representative and a board member of the BIA, I have to respond to our members. I have to be able to say, you know, when they ask, how is your feeling on this process? How do you think everybody did on it? And I don't have answers because January, when we were here, I understood there were going to be 3 issues looked at. I understood that you were going to go back and come to us in January 30th or sooner and say, you know, that interest rate isn't reasonable. It took us 10 to 12 years to levy the tax, so we're going to give you that period of time and not charge you interest on whatever the settlement is. I thought that there was also a decision that you were going to look at that corner lot and the presentation that Mark made. So to find out that somewhere along the line a motion was quickly passed, I certainly didn't hear the motion or understand the motion. I thought that you were going to come back and look at that. And then the issue around Pat and the tenants, which is a very valid issue. The people in that park are competitive, and if one business has to increase their rent, they're not going to get tenants, and it may be an increase substantially. So you have put a suggestion through to the councillor that you know, may help or may not help. So I'm here to support those individuals, those property owners who still have issues, who don't feel that they haven't been resolved. And, you know, I'm hoping that you'll take that into consideration and at least set up an opportunity for Mark to sit and talk to somebody about it to ensure he's satisfied. And for, while you're doing it with Pat, again, maybe somebody from the court or even Tim, to ensure that Pat himself is satisfied on the outcome, because I don't get that sense, and I won't be able to pass that sense along to anybody until, you know, they are satisfied and they can say, yeah, we had a really good feeling about what happened and people listened to me. So thank you very much.
Well, thank you, and thank you for coming back again. Does anyone have any questions? I will stay there for a minute because I want Mr. Mark to comment. But I also wanted to say that, you know, perhaps we need to have our legal counsel, our Court of Revision's legal counsel, Janet Bradley, speak to what the role is of us and what we are capable of doing. Because I think that that is something, you know, even ourselves, for example, the Court of Revision is a new thing for us. It is certainly something that's been around for a long time. There has been changes in provincial treatment of it. Having said that, though, when you come into this room and you come here on any other day for any other meeting, we're in a different role. And much of what I've heard discussed today is about that other role. And so it's why we're not, if you feel that we're not listening to you in that venue, it's because in the role of the Court of Revision, it isn't we don't have the ability, we don't have the role to do so. So, Mr. Mark, I know that you wanted to comment on a few of the points.
Well, just the first point, Madam Chair, with respect to the interest rate, and there is no interest that has accrued on this that is being billed to the owners from June 2001, whenever construction started on the project, until the time the charge is actually approved by this Court of Revision. There's no interest that has accrued during that 12-year period, Madam Chair.
I understand that. I think it's the payback now. It's the interest that if you pay it up front within a period of time, I don't have the documents in front of me, and if you choose to pay it over payments, that you'll be charged interest in year 2, 3, or 4, something along that line, Tim.
Madam Chair, if I might, and maybe I'm going to look to either the Treasurer or the Deputy Treasurer responsible for revenue. I have a recollection, and I'm stepping outside my area of expertise, but that the rate we're charging at 4.5% is likely less than what would have been charged in 2001, 2002. But perhaps the people who know these things can comment.
Madam Chair, that is actually correct. The interest rate yet we will still be setting. It is not quite finalized because the report didn't actually specify. It said what our borrowing rate would be, and at that time it was 4.5%. It is less today. So we will be, once we have the numbers finalized and we go out, we'll be setting the interest rate at that point in time, and I would expect it to be, if this is 10 years, this will be under 4%.
Well, that's good information. And so,
did
you have
0.9% for new car loan? I just thought I'd throw that out there. I think
new
the argument again that was going to be looked at.
Yeah.
I think the argument or maybe the statement I'm making is I understood from the January meeting that it would be considered whether there'd be any interest rate charged for some period of time as opposed to. And so it's not the 4% I'm challenging, and I'm not challenging anything. I'm here in support, so it looks like it did get looked at, and it has been decided that there will still be an interest rate, but that information didn't come back to anybody.
Madam Chair, in the report that Council approved back in 2001, it indicated there would be interest. So that was approved, so we can't deviate from that unless you go back to Council. What we have done in the Finance Department, though, is looking at this. Under the Act, it says you pay it all up front in one sum, or you pay it over 10 years. And what we have decided is to be more flexible with respect to that. So if people want to pay it over 5 years, or they want to pay it over 2, we will entertain those arrangements with them. There will be, though, interest charged for anything that isn't done as one payment to the city at the front end. Anything that's spread over time, unfortunately, because of the fact that it was approved way back in 2001 or 2 with interest on it, there we have to charge interest because the city is, as Mr. Mark pointed out, this money has been spent. The city hasn't is not charging for that time period the cost of money in that time period, but it is a cost to us because that is money that we could be earning interest on during the 10 years if that's what they take to pay it.
Okay, outside of the realm of the Court of Revision, and just speaking to what you said now, when this is approved or not approved by the Court of Revision, the schedule will go to Council for approval? It doesn't go anywhere? It just is approved?
If I may, for 2001, 2003 local improvements, once it's approved, it'll be certified by the clerk, and this will be a 21-day appeal period. We'll give notice, and then people have 21 days to appeal to the Ontario Municipal Board. I'm going to assume for the moment, perhaps naively, that there aren't any appeals, and then the letters will go out. For the later local improvements, there is actually a bylaw that is passed by Council to formalize it, but it's not a matter of discussion or deliberation by Council, it's just a formality. But that formality doesn't even exist for the 2001, 2003 local improvements.
Ms. Bradley, did you have anything to add at all?
No, I don't. Just really to qualify
Microphone.
Really, just to confirm what I think has already been said by the chair is that the role of the Court of Revision is actually quite limited. You really have one role, and that is to approve the special assessment that has come about as a result of the local improvement, and you can only make adjustments to that as a result of provisions that are in the Act, and you have no jurisdiction beyond that. So again, your jurisdiction is limited to approving the special assessment, and that is it.
Madam Chair, I think as we better understand the process, this will make it easier for us in the future, and hopefully nothing like this happens again. It might have been nicer for everybody to have had an opportunity to have a discussion about their individual levies with someone prior to it coming to the court, and then we wouldn't be there wouldn't be this anticipation that you could solve all these problems for us. And I certainly do understand the role, and I understand the challenge you all feel and have with your different hats. I feel like one of my children who's not getting the answer that they really want, though, and keep repeating it a variety of ways. The agreement goes back to 2001. There is an expectation of reasonable time, though, and so to look at an interest in that agreement and try to apply it today after a period of unreasonable time has gone by, I think, somewhere along the line somebody would be nice. I don't think anybody should. I can't direct that, but it would have been nice and would still be nice if that could be looked at. Do we have an opportunity to speak to council on this? Once this goes to council?
No, it doesn't go to council.
So it's done after kind of.
When we make a decision here, it's done.
Okay.
As far as the arrangements of the specifics and that stuff, that part of it, obviously, our city treasurer did say that will be her staff that are working on those elements.
Would you like flowers or candy?
Sorry. You'd have to sign up as a lobbyist or something like that, I'm sure. And I don't think the Children's Place wants to be that.
No.
Thank you very much.
Thank you very much.
Thank you. Anybody, nothing else? Okay. Okay. Glenn Lucas? He left? Oh, he was here on Leggett, it says. And so our next delegation is someone who actually is a counselor today, Marianne Wilkinson.
Thank you, Madam Chair. What I want to talk to you about is how a court functions as opposed to how a council committee functions. Because I really feel that the way you're making decisions is more like the council committee procedure. If I go to court and there's a court and you put in submissions to the court, when the judge makes their decision, they give a decision and they give you reasons. And what the people here have been saying is, I put things in, you've made a decision, but you haven't given us the reasons. And I think it's really important that as a court, that is a responsibility that you actually have, because you are acting as a court. And there is a procedure that can be followed for people to make appeals and all the rest, just as there is in any kind of a court. And I would like to see that the way you respond to this is that you actually say, I'm not asking you to change your decisions. I think that's the decisions that you make. But I am saying that if you've made that decision and there were submissions on certain things that are not being met because of your decision, you have to say, with regard to this is the reason why we did not accept it. This is why we did not accept it. And if there are 20, as your solicitor has said, then there may be 20 different things that you have to do that. But I think it's something this court hasn't sat for a long, long time, and I think there's probably things have gotten sort of missed about how courts operate. Because I see it, the kind of motions and things, we do that, that's how we do it at council. And people can come and speak to it, but when we make the decision, we verbally will tell them why we're making the decision possibly, but that's all, and they have to appeal it to find out more reasons. But usually there's a big report that has what really the reasons why you're making that decision. We really don't have that in this case. So that's the point that I wanted to make, and I think you should think about how you can deal with that, because you're going to have a whole bunch of these coming forward. There's at least a number. I think I was glad to hear some of them have been resolved already. But this is the longest standing one. It's probably the biggest one financially, and it's the most complex one. I do thank you for what you said about, I mean, we will meet with staff about the issues we have in the business part of it. That's a different issue. We have now a BIA. We're just getting moving going, and it's one of the things we wanted to take up with the BIA was how can we make sure we support and keep business in Ottawa, because it's incredibly important for the community. But they've paid over, Canada Research Park alone has paid over $3 million in development charges, for example, and they've not gotten very much for it. They bring in a lot of tax revenue to the city, and they're sort of feeling like, as a business, we've been doing our job, we've been paying you every year, and you've let this one slide. And they're really quite upset about that. And the business improvement area actually sent a letter to the mayor on this on behalf of the businesses that were impacted. So it's not something that is just one or two people. It's really a how-to. How are you going to deal with these things?
Well, thank you for taking the time. I do want Ms. Bradley to comment on that, on the issue of
reasons
and best practices and that sort of thing in other courts of revision.
The Court of Revision is an unusual quasi-judicial body. It gets its jurisdiction from provincial legislation, the Local Improvement Act, and there is no requirement specifically in the Local Improvement Act that there be written reasons in response to every submission that is made. It functions as a quasi-judicial committee, but not specifically with the formality of a court. Certainly, I understand that what the court has been doing is, in fact, making its decisions on the basis of reasons, and so the issue may be whether or not those reasons should be in writing. But clearly, I think one would understand that the court heard all of the submissions, and in not accepting the submissions that were made by certain people, such as Mr. Heyman, then we're adopting the arguments and responses that had been made by the city in its written and oral submissions to the committee. So I think that's all that one can say on that right now.
Thank you. And so,
could I just respond to that as well? I mean, in reason, you said they don't have to give it in writing, but they didn't even give it verbally, and that's why they're a little confused about the fact of what you actually approved. And I remember that happening at the very end of the meeting. All of a sudden, there was a motion, they passed it, and there was no discussion on it at all. So the presentation are made. You already had the motion there to move, and you just said carry. So the people don't really. These people didn't really realize you've done that, which is an indication that the reasons for actually making that decision were not clear to them. And I think it's really important that, because it is a quasi-judicial body, that reasons are clear, whether they're done verbally, which is an option. I prefer to see at least a basis of that in writing, but I'll leave that with you. It's your decision to make, but I think it's something that you really should talk about yourself and decide how you're going to handle it.
Thank you. Member Moffat?
Just to Ms. Bradley, if we, Member Harder and I were just speaking about this, and we spoke about it briefly before the meeting as well. If we provide written response with our rationale to Mr. Heyman and Mr. Ferris, is there any onus on us to provide to all other participants, or just can we provide the reasons to the people that have provided submissions here today?
Well, one would expect that if you conducted a practice where you were going to give written submissions to any one person, you would have to give written submissions to any person that had made submissions to you. Now, there may be ways that you could generalize. If you have 5 or 6 people making submissions on the same matter, then clearly you could generalize. But again, really in response to Councillor Wilkinson, there is no obligation per se to debate the issue as you do as a committee of council in the legislation, and of course courts usually and often don't engage in discussion amongst themselves and do that often outside of the chambers. So again, We are dealing with legislation that isn't very specific, and these decisions will have to be made by the committee over time as to the best way to proceed.
I wasn't actually asking that you submit to each one individually, but within the minutes of your meeting, if you would just have a brief explanation of what the reasons were, that would cover all of them together. So it's a little less work than trying to look at each individual one and trying to figure out who said what, which can sometimes be rather difficult. I'm suggesting it because you've got some more coming up too, and I'm sure you're going to run into this same problem with others. And I think it would be really important, because you're fairly new in this, that you have some procedures of how you're going to deal with it. So I'll leave that.
Well, I believe that we have a procedure, and this may be our first issue that we're dealing with. Obviously, it's the Easter Bunny that keeps on coming back, but we have listened, and what we can deal with, we have dealt with. We have also had a report from the City of Ottawa. We have our legal advice. We've heard from our treasurer, and when you think about, if I think right back to the very first time we had a discussion on this at all, or that the Court of Revision first sat, the comments, with the exception probably of Mr. Heyman's comments, have been pretty consistent. So if we were to have that discussion about the one letter, I think that, who was it that you said that could go out to a grouping of 6 people based on a decision? I mean, one of the things that has been quite prominent here, though, is the delay in the go forward from the original agreement. That's not something that we can deal with.
I understand that.
We can't deal with that. And so therefore, you know, with all due respect, some of the submissions that we're talking about that, you know, giving, for example, hang on a second, you know, has failed to explain their reasons for delaying the imposition of this levy for over 10 years. That's not something up for debate by us or even comment. I mean, there wouldn't be a reason. As far as I'm concerned, what we can comment on is after hearing the submissions, reading the submissions, seeing the staff report, getting the information from our legal expert and our city treasurer, et cetera, on the way to go forward, that's what we base our decision on.
There's 2 I can think of particularly that are specific that you could make a decision on. One is that corner lots in one corner are dealt with in one way, and another corner are dealt with in another way. That was one of the points that Mr. Heyman raised, and that has not been dealt with. The other one he had raised was, if you've had a local improvement done and work done, and the city comes to do something else and charges for the same things over again, that's something you can deal with. The other ones, I agree with you, are outside your purview. I'll leave that with you.
I believe, unless my members feel differently, that we have dealt with that. And you can see that we've dealt with it in ways because we have had further consultation between the staff. There has been reductions. There has been reductions in frontages. There has been reductions in cost per meter. And that was done previous to today. Today we're talking about the recommendations on the Kizil drain and to finalize the local improvement special assessment role. Member Kadri?
Thank you very much, Madam Chair. And just coming back to the request from both the delegation and the councillor about reasons. I mean, some of the decisions that were made by the Court of Revision were based on those reasons in terms of what Councillor Harry just said, in terms of some reduction in value or assessment. Those were done because of the reasons that were presented at the last meeting. So if you're looking for reasons why the Courts of Revision decisions were made that way, those are some of the reasons why we've made those decisions.
I don't think the court actually made the decision of reduction. That was done at City Council.
No, it started here.
Started here. Okay. Started
here. So we have taken that into consideration, and we were the lead on all of that. Having said that, we, with regard to the corner lots and that you were talking about, and as far as the work that was being done for another purpose than that, I mean, we took that into consideration when we made our decisions. I'm not going to change my mind on that. I don't think either of you. We made that decision. We're sticking with it. Putting it down on paper, in that regard, I don't have a problem further to this meeting, and maybe rather than set a precedent, we're always going to do that. We will, specific to something like that, where there is a particular issue, we will we could do that, but I'll look to my, there's nothing wrong with doing that, correct, Ms. Bradley?
There's nothing wrong with making your decision without having it debated, if that's your issue. Question.
Member Kadri?
I mean, debated in this particular room.
Yep.
Just one more question, Ms. Bradley, is if we were to do that with this particular issue as a quarter revision going forward, are we setting example going forward? Or as Chair Member or Member Moffat mentioned, that in terms of other parties that are involved in this issue, are we setting a precedent for them that we have to respond to give them the same reasoning going forward?
I think what may be being sought is some kind of standard practice that will become the norm for these types of proceedings. And maybe you can't do that because it may depend on what issues are raised on a case-by-case basis. But certainly, with respect to the reasons that were, with respect to the submissions which were made that Mr. Heyman made, it is clear that you did consider and debate the issue, and you did come back, and as a result of that reasoning and discussion that you had, made a decision, and that is your job.
Thank you very much. Thank you, Madam Chair.
Thank you. Thank you. Anyone have anything else? Thank you, Councillor Wilkinson. Any discussion on this? On this that we can actually deal with? It's great that we had a discussion on a lot of other things, but so, trustee, not trustee, too many boards, too many committees.
So, Madam Chair, just one question that I'll put out for Ms. Bradley. So far this morning, we have heard no discussion on the Kizzel Pond issue, and that was the reason for this meeting. Is there any other process that we need to do to address that Kizzel Pond issue, or this is it this morning?
Well, you have to make a final
Your microphone, please.
You have to make a final decision on the special assessment.
Okay. Thank you. Thank you, Madam Chair.
Anything? No? Yes, Mr. Mark?
Thank you. If I may have a closing submission. So what the city is asking you to do is that the Court of Revision receive and approve the local improvement special assessment roll for the Leggett Drive roadway urbanization process as stated in Attachment 6 to the memorandum from the General Manager dated 9 April 2013. That is what the city is asking you to approve, and that takes into account the comments made by Mr. Martin this morning with respect to the undevelopable area due to the Kizzel drain. So we're asking you to approve the special assessment roll as set out in Attachment 6 to the General Manager's memo of 9 April 2013.
Thank you. Anything else? Sure. Member Moffat?
So I'll move that we approve the local improvement, receive and approve the local improvements special assessment role for Leggett Drive roadway urbanization project as outlined in the report.
Thank you everyone for attending today. Any notices of motions? Any inquiries? Any other business? So we're adjourned until our next meeting, which is June 24th. So it's been required and several other. Thank you very much. Okay. Sorry.